So in the last video of the Partnership Act series, we have seen the different kinds of partnerships that can exist. In today's video, we'll understand the different kinds of duties a partner has towards the other partners and the firm as a whole. Today we'll cover 3 sections, namely section 9, 10 and 11, and we'll understand everything that is to understand about these sections. Hope you will have an informative and enjoyable journey for the next 15 minutes or so, as long as this video lasts. And all that being said, let's start today's video. Hey guys, my name is Akash. I'm a final year law student in South Calcutta Law College and you are watching Lawve. So now we're getting into the kinds of duties of a partner. A partner, as you can understand, will have some duties towards the firm obviously, but also to her partners, to her other partners, right? And 3 of such duties has been enumerated in section 9 of the Act. Now, if you follow the wordings of section 9, the first of those duties is that a partner is bound to carry on the business of a firm to the greatest common advantage. Now, the question is, whose common advantage? The partners. The greatest common advantage of the partners. It means that anything a person does in the capacity of being a partner to the firm and in the agency of the firm must be done in a way so that all the partners can derive the greatest advantage out of that transaction. Now let's understand that with an example. Let's say A and B are partners in a partnership firm and both have a 50-50 stake in that partnership firm. Now, A is authorized to deal on behalf of the firm with a third party for a particular transaction. Now, A can go about the transaction in 2 ways. In way 1, A will derive a personal profit of rupees 100 and the firm will have a profit of rupees 200, right? Now, in this process, at the end, the personal profit of A will be rupees 200, 100 of his personal profit and 100 for the profit of the firm because they have a 50-50 stake, and the personal profit of B will be rupees 100, right? Now, there is another way to go about the transaction. A has another option. In this option, A will not derive any personal benefit, but the firm will have a profit of rupees 300, right? Now, in this particular process, A will have a personal profit at the end of the transaction of rupees 150 and B again will have 150 because they have 50-50 splitting in the business. Now, which of this process do you think provides the greatest common advantage to both the partners? Take your time. Way 2, isn't it? Because even though in way 1, A was making a profit which was more than way 2, B was making a profit which was lesser than way 2. And the principle of greatest common advantage enshrines that the business has to be conducted in a particular way where both the partners or all the partners, in case there are more than 2 partners, all the partners derive the greatest benefit out of the transaction that they possibly can. And only then the principle of greatest common advantage is maintained. And thus, way 2 is the way to go in this transaction and way 1 will be deemed as unfair dealing. Now, this example was to make you understand the concept of greatest common advantage. But in the real world, scenarios are rarely this straightforward. To give a perspective, let's alter the situation in way 2 a little bit. So let's say in way 1, the transaction remains same, right? But in way 2, that is when A does not make a personal profit, the firm incurs a profit of rupees 100 only. Now, at the end of that transaction, both partners will have only 50 rupees as profit. 100 by 2, 50. Now understand, even though in the first way, way 1, A was making a personal profit, he still was getting B a profit of rupees 100. And in this case, in way 2, B is only making a profit of rupees 50. So which way should we go about now? Which way to follow now? The way where A deals fair and square, which ends up with B having a meager profit of rupees 50, or way 1 where although A gets a personal profit of rupees 100 but also gets B a total profit of rupees 100. Which one should I follow? So for all practical purposes, in these kind of cases, A will be allowed to deal in way 1 and have a personal profit of rupees 100. But since this profit was incurred while transacting in the agency of the firm, this profit has to be divided among the partners of the firm according to the profit sharing ratio of the firm. So a profit of rupees 100 will have to be divided among A and B, and thus at the end of the transaction in way 1, both will end up with a profit of rupees 150 in hand. Now, if A does not disclose this personal profit, and even you can understand, for all practical purposes, she will not. In that case, B is entitled to file a suit. If she finds out later, she is entitled to file a suit and recover the money from A. And that's exactly what happened in the case of Bentley v. Craven. Bentley and Craven were partners in a business as sugar refiners. And for the business, Craven was entitled to buy sugar for the refinery, right? Now what Craven did very smartly, he supplied the refinery his own sugar at market price. But this sugar he bought at a very lower price and thereby made a considerable amount of personal profit, right? Now, Bentley later find out about this small scheme of Craven and he filed a suit, and the court held that Craven has to account for the personal profit that he has gained and make good Bentley. So now I hope the concept of greatest common advantage is clear to you with all its theoretical and practical aspects. Now we can move on to the 2 remaining duties that are mentioned in section 9. They are very easy. So duty 2. The partners must be just and faithful to each other. I mean, that is obvious. If you're not just and faithful to your partners, how are you going to continue your business as partners? In the case of Bentley v. Craven, Craven was not faithful to his partner. He should have disclosed. He basically cheated by not disclosing that he has supplied his own sugar to the refinery, and thus the court has held him accountable. So you have to be just and faithful to your partners. Duty number 3, as you can read, is the duty to render true accounts and full information regarding all things affecting the firm to any of the partners or her legal representative. Now, this is a right and a duty in the same sentence. As a partner or legal representative of a partner, a person has the right to see the full accounts of the firm and also receive any information regarding the firm that affects the firm. And at the same time, as a partner, she will have the responsibility, has the legal duty to provide the true accounts and full information of anything affecting the firm when asked by any other partner or her legal representative. These 2 points are as simple as that. The first point, the greatest common advantage, was a bit complicated, and I have explained that these 2 are easy. And with that, now we can move on to section 10. A partner commits a fraud in the capacity of being a partner to the firm. That is, while conducting the business of the firm, she commits a fraud. Now, she will be liable to indemnify the firm and the other partners for any loss that has been inflicted on the firm because of this fraud. And this is an absolute duty of a partner, and no partner can contract himself or herself out of such duty. But understand the legal principle very minutely here. As I have said in the previous video, in a partnership firm, there is a mutual agency among all the partners of the firm. So, for the fraud that one of the partners has caused or done to the third party, all the other partners will be equally liable to that third party. And they will have to indemnify that third party, make good that third party, or else face legal consequences. And that, my friends, is the very essence of partnership, which differentiates it from anything like, say, a company or any other organization. right? However, Section 10 here provides that once the partners are done dealing with the third party, they make good her loss. Now they can sue the partner who committed the fraud and indemnify themselves for all the losses that has been inflicted on them. The partner who committed the fraud, he will have to now pay back the partners for any loss that has been inflicted upon them because of the fraud that he committed. But before that, the other partners, they have to indemnify the third party. They are equally responsible, equally liable to the third party to indemnify the third party as is the partner who committed the fraud. So this is something that is very crucial in Partnership Act, and this is something that you need to understand while trying to understand Partnership Act. Right, now let's move on to Section 11. So in Section 11, we have two subsections. Subsection 2 is of particularly importance, but we'll come to that later. First, let's deal with Subsection 1. Subsection 1 provides that the mutual rights and duties of the partners towards each other and towards the firm can be decided by a contract among the partners until any such provision of the contract is in contrary or outside the scope of this specific act. Now that's pretty self-explanatory, right? So unless the partners contract something that is in violation of this act, like for example, if one of the partners want to exclude himself from the indemnity clause in the previous section, Section 10, that will not be allowed. But other than that, the mutual rights and duties of the partners towards the firm can be decided among the partners by a contract between the partners. So that's pretty simple. Now I move on to subsection 2 of Section 11, and this is very, very important. It is one of the souls of this Partnership Act. Let's understand that. Now this subsection 2 of Section 11, this is so important because it provides an exception to a generally settled principle of law. Since you are now interested in Partnership Act, I hope you have already studied Indian Contract Act 1872, right? So try to remember what Section 27 of that act said. It said that any contract which restrains a person from carrying on any legal profession, business or trade is void in law. Now, from where does this section draws its powers? It draws its powers from Article 19, Subarticle 1, Subarticle G of the Indian Constitution, that confers upon its citizen the freedom to carry on or practice any profession or to carry on any occupation or trade or business. Now, this subsection 2 of Section 11 of the Indian Partnership Act, it provides an exception to this constitutional principle. It says that an agreement among the partners restricting all the partners to carry on any other business other than that of the firm will be valid. It will not be vitiated on constitutional ground or because it is against Section 27 of the Indian Contract Act, because the Indian Contract Act is a general act and the Partnership Act is a special act, and the settled provision of law is that whenever in conflict, the special act prevails over the general act. So if the partners of a partnership firm have an agreement among themselves that restricts them to carry on any other business other than that of the firm, that will be completely and absolutely legal. Alright, so I think we'll wrap up today's discussion at that. We'll pick up from Section 12 in the next video. And mind you, the duties of a partner have not ended, and we'll pick it up from Section 12. It also talks about duties of partners. So if you like this video, I'd like to take this opportunity to divert your attention to the Easements Act series that I have made. It should come right here. This is a complete section by section breakdown of the Easements Act 1882. So if you have anything in doubt about Easements Act, you'll probably find it there. Feel free to check it out. And Here's a video of how to get an FIR registered. Feel free to check that out as well, and click the I button to check out some of my other videos that we have made. Alright, so I wish you good health and hope to see you in the next video. Good day or night, depending on when you are watching this. Bye.